Okay, I want to share a few things here. Here's a new motion from the DA in Colorado. People's position regarding the defendant's request to waive a jury trial. Okay, so he says here, February 4, 2022, defense filed a unnumbered motions titled Motion to Change Plea to Not Guilty by Reason of Insanity. In the pleading, the defense notified the court that the defendant wished to waive her right to a jury trial and proceed with the trial to the court, okay, without citing criminal rules. You know how they do. Okay. Pertinent to the people's position, the defendant filed for a change of venue on December 28, 2021. The people filed a responsive pleading on January 7, 2022. And then they go into all these laws, okay, guys? I get really confused by this stuff. Okay, to be clear, an accused does not have a constitutional right to waive a jury trial. So that's interesting. Further, in the absence of a statutory authority, the courts have recognized that while a defendant may have a common law right to waive their right to a jury trial, the right is not absolute. As to the rights afforded to the prosecution is clear in that the people have the right to refuse to consent to a waiver of a jury trial. However, this right is not obsolete or whatever. Okay, the defense, which allows the defendant accused of a felony to waive their right to a jury trial with the consent of the prosecution. This does not qualify the waiver based on the level of offense. Okay. Let's see. However, the ruling does not directly address the waiver of a jury trial in capital cases or Class 1 felonies, and there is still lack of direct statutory guidance. In the absence of, statutory authority regarding capital cases in Class 1 felony, Supreme Court ruled that the prosecution must consent to the waiver of the jury trial, and the trial court cannot guarantee the waiver. To be clear, the trial court should consider the due process rights of an accused, such as prosecution alone cannot compel a jury trial in circumstances where a defendant may not receive a fair trial. Okay. If a defendant's burden to raise due process concern and clearly articulates circumstances which have preluded a fair and impartial jury, the defendant claims that she is prejudiced because it would not be possible to select a fair and impartial jury in the case. The trial can consider the extent to which change of venue may cure the bias against the accused when considering issue of a waiver. The trial court makes a determination whether the waiver of the defendant's right to a jury trial should be granted over the prosecution's objection. Okay, regarding concerns about it, in terms of change of venue, the burden is on the defendant. A warrant of change of venue, the trial court must consider factors shows that publicity and a massive to create a presumption of an unfair trial. All this legal mumbo jumbo gets to me. Okay, the size and type, the reputation of the victim, the sources of news stories, the account of certain facts, the volume, intensity of the coverage, extent of the comment by news reporters on the facts of the case, the manner, the time length. Okay. Prejudice only exists in rare and extreme circumstances. The people hereby objects to the defendant's waiver of jury trial and thus do not consent to the defendant's request for one. Given the people's objection, the holding, I don't know these, whatever. The defendant's burden to show that she cannot receive a fair and impartial trial, and she has not made that showing. To date, the only evidence the defendant has put forward for the court to consider is her assertion that there has been large amount of publicity in this case, and that by virtue of this case receiving this publicity, her right to a fair trial by an impartial jury is threatened. Okay? Defendant has only made an unsupported assertion that she faces a threat of not receiving a fair and impartial jury. She has not met her burden. The court should deny her request. Okay, change of venue has already ruled that it cannot address the issue of venue until jury selection begins. Oh, I didn't know that. Court may seek to redress the matter of her waiver of a right to a jury trial when the court rules for the motion to change venue. It's important to note the state of Colorado, there have been a number of high-profile cases involving large amounts of publicity where a fair and impartial jury was impaneled without the need of change of venue. So they're asking for the court to deny. Okay, and I just want to give an update of the upcoming hearings, which is February 2nd, 2023, and those are motions. And the trial is set to begin 3/20/23. Okay. Also, don't forget, just GoFundMe for Landon. Help Gannon's mom get justice. So I'll put the link to that. So let's not forget about that. Also, street name for Gannon. Okay, this change.org here. Also, Gannon's Law. Don't forget to sign that. And this here, I don't know if it's still going on, but for it to be televised. But I think it will be. I don't think there'll be no worries there. But you never know. Okay, and I'll share this. Okay, the record reflects Letecia was previously represented by Public Defender's Office there in Colorado. And there was a hearing that occurred on February 26, 2021, where she decided to represent herself. She was granted that. On the 28th, the court received a letter from her in which she requested the court-appointed counsel to represent her. Then the court reappointed the Office of Public Defender. Okay. However, Letecia also raised the issue of conflict with the Public Defender Office, and a hearing was held, and then she got to have tortellini, or whatever you call them. And if you guys remember, this is a letter they were talking about. So she had a conflict hearing, and she says here, February 19, 2021, I was unable to talk with Judge Bain about my conflicts with the defense team due to 1. The actual privacy of the booth and the transport over. I explained in detail to him, expressing my concerns of privacy. Number 2, I had a very difficult morning mentally because I am not mentally well. One of the main issues with my attorney is their lack of ability to gather evidence. Due to this, I find little value in the term expert. First, they were unable to obtain my medical health records from Charleston, South Carolina. When I finally paid a firm in South Carolina to obtain them. Okay, in 2016, I was diagnosed with 1 received treatment before work for over 28 hours of care. Okay, it's a tongue twister, you guys. It don't make sense. The school district even provided extra services and later let me medically resign due to the ongoing reality breaks. In 2018, I was hospitalized in Canada, crossing the border for 2 days, and completed more of treatment when I returned. I tell you this because it sets a stage for me and why I cannot work with my attorneys. Let's see. I signed release forms for them to get all this information so they would have a better understanding of why I'm all over the place some days. I asked them to use the info from non-biased doctors who worked with me more than 2 hours, but instead they sent a lady who is clearly an actress and friends with the DA. She spoke about him in an unprofessional manner. Okay, their history and his election. Now I'm sure all this was true, but I thought she worked for the court. not one particular side. Okay, my attorneys did this to make me look like a, I don't know that word, some kind of individual. Instead, it was manipulation. My God, what does she say? On their part. I have included several reasons to support my claim. Okay. Communication is broken beyond repair. I explained these issues to Judge Bain, including the lack of access and visitation to complete detail. Inconsiderate of evidence, March 2020, I asked my attorney to preserve the GameStop footage, to locate the Texas police officer whom I spoke with, and to get the cruise passenger list. Instead, they spent months contacting my family for mitigation. When asked certain things, they kept saying they will let the investigators know. 1 year later, same answer. My evidence. I haven't physically seen any while being held at the CJC for 1 year. Yes, COVID, but inmates were still being held as our constitutional rights were adjusted. Okay. Overseeing statute and evidence. They overlooked the comp statute about video recording, human error. Okay, but this happens often with evidence, in which me, the non-expert, has to provide corrections with evidence. Oh no, I forgot she said that. Sharing info. They were texting my family and giving them info that should have been causing several disputes. My judge. They filed that motion knowing this county would not grant me new attorneys to sabotage my chances by a trial by judge. They knew I wanted to present evidence to him without exposing any info on my son's father. However, they created incorrect conflicts instead of addressing the real issue. They could have filed the pro se only instead of talking about my defense to sabotage my trial by judge. Defenses. Indeed, I am innocent, but I will not put myself or others in danger running the defense against my biological son. When the system is letting two run free who are involved, one is prominent member of the independent business. They use the NGRI to get a hearing knowing I'm not guilty to cover up their lack of representation. Although I had bouts of insanity and still do, I did not murder or abuse anyone, nor would that be a defense because it's my understanding that the actual did do it. However, I will protect my bio son. I will protect the drugs and violence documented from my stepson. Oh, you did not just say that. The truth is that the court is holding the wrong person and for the wrong crimes. The whole process has been nefarious, from denying me an attorney, threatening me in the bathroom, away from the cameras to confess, taking advantage of me, being delusional, threatening my other kids' freedom, or else. I am going to keep making it known, just how much the state has done to me in a wrongful incarceration. I will continue to be an advocate for myself because I am not a murderer, and the level of the prosecution goes through to promote a wrongful conviction is absurd. Truth is, they see a video from someone else and they would dismiss that person as a lunatic. They have far way too much invested in this wrongful incarceration to admit that they were wrong. For the reasons and because my defense team is in cahoots with them, I am left with no other choice but to represent myself, denying me my rights under the Constitution has happened throughout this process, from the detectives at jail and on my legal team. Every day I'm getting worse mentally due to inadequate representation and being held hostage for a crime I did not commit. These are my conflict issues and my reason for asking to go pro se. As always, thank you. So yeah, that was on my letter, you guys.